The law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome to our ongoing coverage of the Minnesota murder trial of Derek Chauvin over the in-custody death of George Floyd. I am Attorney Andrew Branca for Law of Self-Defense. Today's content is sponsored by CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay their members legal expenses if their member is involved in a use of force event, and those expenses start big and get bigger fast, folks. A typical aggravated assault charge, which can happen if you simply point your gun at another person in self-defense, don't fire a shot, don't hurt anybody, can risk a 10 or 20-year felony sentence and cost as much as $30,000 to $50,000 in legal fees to defend, and that's just for the pre-trial expense. If you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the legal resources you need to fight the legal battle the way you'd want it fought. Now, I've looked at all these types of services you might imagine, and I found that CCW Safe is the best fit for me. I'm a member. My wife, Emily, is a member. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCWSafe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Today started off with a major shift in the court's proceedings, with the state resting its presentation of its case in chief and the defense beginning its presentation of its own case in chief to the jury. The ball is now in the court of the defense. Up to this point, the defense was limited to playing, if you'll forgive the metaphor in this context, playing on defense. With all the witnesses so far having been called by the state, it was the state that controlled not only who would testify at all, but also the scope of that testimony. While the defense had the privilege to cross-examine the state's witnesses, cross-examination is limited to the scope of direct questioning. That is, if the state didn't ask about it on direct, the defense couldn't ask about it on cross. Now that the tables would be reversed, with the defense able to call witnesses that the state would rather the jury not see, and the scope of the questioning of those witnesses would be controlled by defense counsel Eric Nelson and not by the prosecution. Throughout the day, the defense moved speedily through 6 witnesses, including retired MPD officer Scott Creighton, who was involved in Floyd's year-earlier arrest-related drug ingestion event, and whose testimony included body camera footage of that event. Retired paramedic and nurse Michelle Mosang, involved at the same event, and the person who had observed Floyd's sky-high blood pressure of 200/160. Shawanda Hill, the woman in Floyd's SUV on May 25th, 2020, the date of Floyd's death. Minneapolis Parks police officer Peter Chang, who was present on duty at Floyd's May 25th, 2020 arrest, and whose testimony included his own body camera footage of that event. Minneapolis Police Department Medical Training Coordinator Nicole Mckenzie were called as a defense witness after testifying for the state earlier in the trial. And finally, perhaps most importantly, Barry Brode, the use of force expert witness retained by the defense for this trial. Now, I'll state up front that all those witnesses were helpful to the defense narrative of innocence in this case to at least some degree, really without exception. In my view, however, the 3 most important, at least in the context of the defense case in chief that we've seen so far, were use of force expert Brode, Parks officer Chang, and Floyd ex-girlfriend Shawanda Hill, as well as arguably the body camera footage of Officer Creighton. But I'm going to mostly focus on Brode, Chang, and Hill, and then just provide you with the videos of the testimony of the 3 other witnesses embedded within the text version of today's content. So let's start with Barry Brode, defense use of force expert witness. Now, he is, however, perhaps the witness unquestionably, the witness I'll spend the most time on here in this blog post, in this video, in this podcast, depending on how you're consuming this content. And I'm sorry to say that's not because he did a great job on the witness stand for the defense. Indeed, I found Broad's performance to fall rather astonishingly short of what the defense needed in this case, particularly in the specific context of use of force expertise. In my live blogging comments today, I, at one point, characterized Broad's performance as a train wreck for the defense, and I expect some folks will think that's too extreme a characterization. Maybe his testimony was far from perfect, one might think, but he hardly became a witness explicitly favorable to the state, as had several state witnesses become favorable for the defense. Maybe a fairer characterization is he was not great, but also not terrible. The answer to that question is a hard no. Maybe in a more normal case, a mere not great would be enough. But this is not a normal case. Even just considering the legal dynamics alone, the state has just spent a bit over 2 weeks presenting a great number of witnesses, including many highly credentialed expert witnesses, all questioned by a rotating panel of 4 skilled prosecutors. Further, there are 2 main paths of attack for the prosecution on the facts of this case. First, that Chauvin's conduct was a substantial contributor to Floyd's death, and perhaps even the primary cause. And second, that Chauvin was not justified in his use of force upon Floyd. Now, it's true that the state must win both those battles. If the defense wins either of those legal battles, that is, convinces the jury either that Floyd died of other causes, absent substantial contribution by Chauvin, or convinces the jury that even if Chauvin caused Floyd's death, he was nevertheless justified in his use of force upon Floyd, then as a matter of simple legal reasoning, the prosecution cannot prove Chauvin guilty beyond a reasonable doubt, at least not on the legal merits. The state, recognizing this dual challenge, has brought a huge mass of evidence and legal argument to both of those battles. Frankly, to an extent that I think many judges would have found much of the state's evidence to be cumulative and, as a result, inadmissible. In the context of the mechanism of how Chauvin purportedly caused Floyd's death, they've attacked on multiple fronts, including blood choke, respiratory choke, positional asphyxiation, denial of care, and probably some I've not even bothered storing in memory. In the context of the purported lack of justification for Chauvin's use of force upon Floyd, the state has brought forth a plethora of Minneapolis police officers and senior management, all testifying as to MPD use of force policy, as well as use of force experts, to provide testimony to that effect. Now, frankly, I've always felt the best defense for the defense was on the justification for use of force front. The state's testimony in this issue was sketchy at best and often catastrophically bad for the prosecution. Several of the state's police witnesses on this front were effectively turned into defense witnesses by defense counsel Nelson on cross-examination. Further, I had little difficulty envisioning a narrative of justification for Chauvin's use of force upon Floyd for every moment of the event encounter between Chauvin and Floyd. In contrast, the medical defense struck me as much more challenging for the defense, especially with the number of well-credentialed medical and scientific experts the state brought in to testify. Again, arguably in a manner that was impermissibly cumulative testimony, but nevertheless it was allowed. Use of force justification on policies are vastly easier to explain to a lay jury than are the medical sciences of cardiology, pulmonology, oncology, physiology, and more. For that focus on the defense of justification to work, however, it had to meet a particular condition, and that is it had to be near perfect, virtually pristine in its clarity, compelling in its obviousness, undeniable in its correctness. A half-hearted effort would not get the job done. And that's just in the legal argument context. Throw in the political context and the racial context and the rioting, looting, and arson context, and it is all the more important that the defense approach perfection if it is to have any hope of achieving an acquittal on the basis of a use of force justification defense. So while I could not possibly know how Nelson was going to craft that narrative of justification, I knew what it had to look like by the time he was done, and I could envision how I would go about achieving that state of virtual perfection in a justification defense if I were making the effort. I could see it from here. It's that state of near perfection that use of force expert Barry Broad needed to deliver today. And when I say I felt much of his testimony was a train wreck, it's in the context of that very high expectation and standard and, frankly, requirement. Was Broad okay? Well, sure, he was okay. Sometimes good, sometimes not good. Overall, mediocre, okay. Did he even approach the perfection necessary in this case? I'm sad to say, not even close. So let's dive into Broad's direct questioning by Nelson. Frankly, I thought Broad was weak from the very start, even on direct questioning by Nelson. In all fairness, however, the primary fault for that lies probably not with Broad, but with Nelson. He's the conductor of the symphony now, and had the mission of extracting from Broad a near-perfect narrative of justified use of force. Ideally, this narrative would address not only the defense narrative of justification that looked good when considering the facts in only a favorable light for the defense, but one that also addressed points of attack by the prosecution. Indeed, that addressed every possible point of attack by the prosecution. It was largely on this second point that the direct questioning of Broad fell short. It left vulnerabilities. Sure, Nelson got a narrative of justified use of force out of Broad, but it was one that appeared had never been prepared or stress tested for resilience against cross-examination by skilled and motivated opposing counsel. It looked good on the surface, but the failure to effectively armor this narrative of justification against attack on cross-examination left that narrative and expert, Broad himself, humiliatingly vulnerable to damage on cross-exam. And that's on Nelson. Much more so than it is on Broad. Leadership gains the kudos of success, but also bears the responsibility of failure, and Nelson is the leader in this particular relationship. That said, I personally cannot imagine ever recommending Broad as a use of force expert witness in any case in which I'm involved, not after his performance here, as well as in the trial of Chicago police officer Jason Van Dyke, who would go on to be convicted of murder in the shooting death of knife-wielding Laquan McDonald back in 2014. And I'm sorry, that's my opinion, even if Broad were free of cost, much less if he billed the $11,000 plus he was paid for services in this case. Nelson's direct questioning would have appeared to be going well on the surface, as Broad provided testimony favorable for the defense on point after point. At least it would appear to be going well if one didn't know the likely points of attack that would be made by the prosecution on cross. If one did know those likely points of attack, and I do, it was pretty obvious, even on direct, that they were not being sufficiently armored against those attacks. Just as the state's expert witnesses had done for the state, Nelson's use of force expert witness said the magic words the defense required of him. In effect, that Derek Chauvin was acting with objective reasonableness following MPD and current national standards for law enforcement in his interactions with George Floyd. Nelson also had Broad touch upon a number of truly important points in the necessary narrative of justified use of force. For example, it's not the severity of the initial call that controls how much force may be used, but how severe the interaction becomes over its entire duration. A call for a minor offense could become a deadly force confrontation. Further, how much force a reasonable officer was obliged to use was, at the end of the day, a decision made by the suspect, whether they complied or resisted, and if they resisted, to what intensity. Nelson also had Broad testify about the reality that a reasonable officer was permitted to use force not just against actions being taken by a suspect in the moment, but against actions which were imminently about to be taken, a suspect reaching for an apparent but maybe not yet seen weapon, or even actions taken against heightened risks of harm, a suspect refusing to show his hands or refusing to maintain a position of distance, and so forth. Nelson also had Broad make clear that the factors involved in determining the reasonableness of a use of force included not just the three factors highlighted or bulleted in the Minneapolis Police Department manual: severity of the crime, threat of the suspect, resistance or flight of the suspect, but the entire totality of the circumstances and knowledge possessed by the officer. Broad also informed the jury that an officer could use force even if a suspect wasn't using any force against the officer or others. For example, if the officer had a reasonable suspicion that a suspect had committed a crime and the suspect refused commands to stop walking away, the officer could use force to detain the suspect and even handcuff the suspect without having to meet the higher requirements of a formal arrest. Reasonable suspicion for a detention was sufficient. Now, as discussed yesterday, when Nelson touched upon the issue of proportionality in the context of police use of force upon suspects, I really felt his conceptualization of this was very weak. He once again today presented this concept as one in which the officer is allowed to up-level, or what Nelson described as one-upsmanship, the degree of force against suspects, use one level higher force than the suspect. And Brode fully agreed with Nelson's approach here. But this conceptualization of proportionality, to my mind, has real vulnerabilities to attack, and as we'll see, the prosecution would make full use of them. Nelson also touched upon the relevance of possible intoxication of a suspect or possible large disparity in size or strength between officer and suspect as important factors in evaluating threat and risk in police use of force, and once again, Brode agreed. Again, however, Nelson failed to armor these issues against attack, leaving them exposed and vulnerable on cross. Brode also confirmed that even a handcuffed suspect could continue to be dangerous to officers or others, or perhaps to attempt flight and escape. Further, Nelson touched on the importance of matching a suspect's words to their actions and being alert to inconsistencies, such as fraudulent claims of medical distress, both in that context of claim distress as well in claims of purported compliance. On the issue of positional asphyxia, Brode indicated that it was really only a risk for obese subjects, which Floyd obviously was not. On the issue of the bystander crowd, Brode said even just 2 people could qualify as a crowd if they had gathered for a similar purpose. Importantly, Brode testified that in his view of the videos of Floyd's arrest, he could clearly see Chauvin's attention being distracted away from his suspect and towards the growing and increasingly hostile crowd. Again, the question, did the mob effectively kill Floyd? So far, so good. Then, however, Nelson's direct questioning of Brode opened up a huge target of attack for the prosecution when Brode testified that he didn't consider prone restraint to be a form of use of force at all. Folks, I'm sorry, but that's simply not a reasonable use of the concept of force. It is common police practice to describe even mere physical presence or verbal commands as a form of force. Certainly anything involving the laying on of hands by an officer on a suspect is going to be considered a use of physical force. Going hands-on may not be a lot of force. It may just be minimal force. An escort hold, for example. It may even be the most minimal force imaginable. But it's definitely force, folks. It's certainly not non-force. And the difficulty for the defense of describing prone restraint as zero force is that first, it seems preposterous on its face, especially in the context of George Floyd's prone restraint. But second, it suggests that in that case, only zero force was justified under the circumstances. And when the preposterousness is exposed, the actual use of force revealed, then even the most minimal force appears to be unjustified under the circumstances. So that's all I'm going to comment on the direct questioning of Brode, but of course the video of that direct questioning of Brode by Nelson is embedded in the text version of today's content. Let's jump into Brode's cross-examination. Prosecutor Schlesser would make use of every one of those avenues of attack on cross-examination and more. One indication of the value of Brode as a witness for the state is that whereas Nelson spent about 45 minutes on direct questioning of Brode, the state spent almost 1 hour and 20 minutes on cross-examination of him. Schlesser immediately attacked Brode's view that prone restraint was not a form of force at all. So Floyd in handcuffs, prone on a hard street, that was not a use of force at all? Correct, answered Brode. Not even if the enforced position caused Floyd pain? Well, that position doesn't cause pain. Schlesser asked, shocked. Not even with a cop on top of your back and neck? Not even given the abrasions to Floyd's face and shoulder from the street? And Schlesser didn't mention, but should have, that Chauvin was also gripping Floyd's hand in an explicit pain compliance technique. Given that description, and of course that Floyd was complaining of pain throughout, Brode's characterization of Floyd's prone restraint as being one not involving pain or discomfort appeared ridiculous. Ultimately, Broad would concede that perhaps Floyd's prone restraint could have involved pain or discomfort. Indeed, we could hear could and possible a great deal in Broad's testimony on cross-examination. Unfortunately, that's not a position of strength. But of course, now that means that the prone restraint as applied to Floyd, if it was force because it caused pain and discomfort, was by Broad's own standards, well, a use of force after all. A common occurrence in Broad's cross-examination was that Schlescher would make some claim favorable to the prosecution. For example, that Chauvin's knee was on Floyd's neck throughout the prone restraint, a claim that had already been contested by state witnesses throughout the state's case in chief. And then essentially he would badger Broad on cross-examination. He would badger Broad, the defense use of force expert, into agreeing with the state's position. Another favorite tactic of Schlescher, used in the cross-examination of Broad, was to isolate specific facts of the event, separate them from the greater context of the totality of the circumstances, so as to place them in a light most favorable to the state, and then again badger Broad into conceding that the state's view was either correct or at least possible. Schlescher often facilitated this facts in isolation tactic by supplementing his cross with still photographs of the 9-minute plus prone restraint, or perhaps he would put up isolated 10-second videos, obviously carefully chosen to maximize the apparent reasonableness of the state's position on use of force and minimize the reasonableness of the defense position. For example, is a suspect's intoxication by itself sufficient to justify a use of force by an officer? Can an officer use force on someone merely because they are intoxicated? Well, of course, Broad agreed not. What about a suspect's disparate size? Could an officer use force on someone merely because they were much larger than the officer? Again, obviously, Broad agreed not. Of course, nobody is attempting to justify the use of force on the basis of any of those factors in isolation. Rather, those are among the many factors that play a role in the totality of the circumstances. This necessary clarity of the use of force concept, however, was lost during Broad's cross-examination by the state. Schlescher showed Broad various snapshots of the gathering crowd, starting with just 2 people present, then 4 people, then 6, but all during periods when the crowd had not yet grown loud and hostile, but was still calmly filming events. Was this calm crowd a threat to the officers that should distract their attention from their suspect in custody, Floyd? Well, of course not. And Broad agreed. But of course, what was missing was the relevant context of when the crowd was loud and hostile. What Broad should have done in every one of these instances, every one of these isolated fact hypotheticals, was simply to decline to provide an opinion to a reasonable degree of professional certainty, which is the relevant legal standard for an expert witness of his type, by considering these elements in isolation. He should have refused. He should have explained that his role as an expert witness was precisely that, to deliver an opinion to a reasonable degree of professional certainty, and that meant considering the totality of the circumstances. You couldn't learn anything or understand anything about what happened looking at each fact in isolation. Now, while it's true that witnesses on cross-examination will largely be pressed to give just yes or no answers to questions from opposing counsel, expert witnesses are given considerably more leeway than our non-expert witnesses, just fact witnesses, and Judge Cahill has proven to be inclined to allow experts exactly that leeway. Instead of doing that, Broad would accept the single fact hypothetical, which was, of course, carefully framed so that a yes favored the state, and then agree that the hypothetical was true, or at least possible. These isolated, out-of-context questions touched upon important issues, such as how much weight was Chauvin applying to Floyd, demonstrated by a still photo, as if a still photo of a moment frozen in time could convey shifting weight balance over a 9-minute period. Similarly, it was asked, is it hard to move a suspect into recovery prone position? No, it's easy, answered Broad. Of course, the necessary context also involved whether the officer's attention was diverted to the growing crowd, whether rolling Floyd backwards away from the cruiser would have dangerously exposed both Floyd and the officers to the traffic on the roadway behind them, or even whether it reasonably appeared that doing so was a necessary precaution at all. After all, for most of that 9 minutes, Floyd was talking, and the EMS was believed to be just a minute or two away. Schlesser asked, isn't the passing of a bad $20 bill really a small crime, no matter if the state lists it as a felony, compared to, say, a domestic assault, which the state lists as a misdemeanor, at least in the context of risk of physical violence? Well, sure, answered Brode. Of course, the necessary context here is that the use of force upon Floyd was not premised on his passing of a $20 bill, for which he likely would have ended up with just a summons, but rather for his forcible resistance of the officer's lawful efforts to place him in the squad car. Not even the prosecution contests that the police were privileged to their use of force for that purpose. Schlesser also effectively eliminated the notion that officers were privileged to use force to prevent an apparently imminent threat or to mitigate the prospects that a reasonably inferred threat might incur. Under the Schlesser model, there were either active threats, suspect violence in action at the moment against which an officer could use force, or there were mere risks against which zero force could be used by an officer, period. The simple truth is that not even non-officers have to wait until they are the victim of a violent attack before they can use defensive force. We're all privileged to use defensive force to stop even an attack that merely reasonably appears imminent and has not yet been executed. Another important consideration is that there's a distinction between offensive force and protective force. Sure, an officer may be privileged to use offensive force to neutralize an active attack or an imminent attack or a reasonably inferred risk of an attack, but an officer can also use force for protective purposes. For example, we've all seen in the movies where an officer places a hand on a suspect's head as they place the suspect inside a patrol car. That's a use of force that's not intended to neutralize an attack by that suspect, but to protect that suspect from head injury as he enters the vehicle, and it's completely justified as such. Similarly, if an officer saw an intoxicated person wandering near the edge of a cliff, he'd be privileged to use force to compel that person out of the zone of danger, even though the person presented no active threat to the officer or to anybody else. In this context, there is an argument to be made that for the early portion of the restraint of Floyd, the prone restraint was being used to neutralize any threat he may present to the officers arresting him, or to the process of lawful arrest itself. But maybe for the last few minutes of the restraint, the justification is different. It's based on force being used protectively for the benefit of Floyd, to ensure that he didn't regain consciousness on a busy road, and that he remained present for the believed to be imminent arrival of medical professionals. Under the Schlesser model, however, it was either active threat, force allowed, or no active threat, a mere risk of threat, and zero force allowed. And sure enough, Schlesser badgered Brode into agreeing that the officers could not use force against a mere risk, thus zero force allowed in that context, and surely, Schlesser asked, after Floyd lost consciousness, he was at worst a risk, not an active threat, and thus Chauvin was not privileged under that model to use force against Floyd at all, not even prone restraint. Schlesser also morphed the concept of situational awareness from one in which an officer was obliged to manage a difficult and complex array of sensory inputs simultaneously to a model in which an officer who failed to perfectly integrate every possible value without error failed to meet the standard of an objectively reasonable police officer. And when Brode was questioned by Schlesser on these points, the responses to those questions were yes, 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 and the occasional could or possible. This meant, in the prosecution's telling, that it was nonsense to imagine that the hostile crowd might have distracted Chauvin from a suspect, but rather, we were all supposed to believe that Chauvin had an absolute legal obligation to pay perfect and equal attention to everything, simultaneously, without failure. That, folks, is neither a reasonable expectation for any human being, nor is it a view that, if believed by the jury, makes things any easier for Chauvin's defense. Now, as I mentioned, there's about an hour and 20 minutes of this stuff. The cross-examination of Brode, all about as equally bad as what I've described above. I can't possibly step through all of it in a blog post. I do, however, encourage you to watch the video of Brode's cross-examination embedded in the text version of today's content. There was also a redirect of Brode by Nelson, and I will say that Nelson made up some important ground here, ground that wasn't later greatly diminished by the prosecution's subsequent, very brief re-cross-examination of Brode. But by the redirect where Nelson gained ground, Brode was in a very, very deep hole that he ought not to have been in to begin with. And frankly, I wonder if the fault for that poor cross-examination doesn't really fall to Nelson as well as Brode. Perhaps Nelson drilled Brode hard on how to handle the very predictable attacks brought to bear by the prosecution, but given that Nelson had not preempted those attacks on direct, which he could have done, I'm thinking perhaps that preparation did not occur, at least not adequate preparation. It certainly looks as if it had not occurred. So I've embedded the redirect of Brode and the recross of Brode, both quite short, in the text version of today's content. Now, for me, the bottom line for Brode's testimony, as I said earlier, as the defense use of force expert witness, in this case, a really important witness for the defense, it was his job to deliver a perfect and coherent use of force justification that was largely, if not entirely, invulnerable to substantive damage upon cross-examination by the state. And I know that may sound unrealistic, but I can tell you I've seen it done. It was accomplished by the use of force expert in the George Zimmerman case, for example. Now, because I don't believe Brode accomplished that necessary mission for the defense, in my view, he fell short of the requirements for this trial. I'm not certain whether that's more the fault of Nelson or more the fault of Brode. I am certain, however, that it is Chauvin who faces paying the price. On a more positive note, for the defense, we have the direct questioning of Peter Chang, Parks officer. The testimony of Parks officer Peter Chang was pretty fantastic for the defense, and this includes both the in-court testimony of Chang himself, in person, as well as the, I'll call it virtual testimony provided by the body camera footage of Chang at the scene of Floyd's arrest, which video captured a lot of the quote-unquote testimony by such characters as Shawanda Hill, the female passenger in Floyd's car, and his ex-girlfriend, Maurice Hall, the male passenger in Floyd's car who's taken the Fifth Amendment and will not testify in this trial, and even a bit of Charles Mcmillian, the 61-year-old bystander witness of Floyd's arrest, who is shouting at him to just get in the car, you can't win. Chang was on duty in a nearby park when he heard the radio chatter about Floyd's arrest, including that police were taking someone, Floyd of course, out of a vehicle, and he believed he heard a struggle over the radio, and he self-assigned himself as backup to the scene. Chang had remarkably favorable testimony for the defense, perhaps most importantly that he personally perceived the growing and angry crowd as a prospective threat to the officers on scene. Indeed, he described the crowd as very aggressive. That's a quote, very aggressive to the officers. Unfortunately, not as much was made of this observation, perception, on direct questioning of use of force expert Brode as I would have liked to have seen happen. Even better than Chang's actual testimony in court, however, at least arguably, is what was captured by his body-worn camera. First, the manner in which the footage of the camera continually panned left and right over the scene from where he was assigned with controlling Shawanda Hill and Maurice Hall by Floyd's SUV, and then back across the street to watch where the officers struggled with Floyd, and back and forth, and where the police were struggling with Floyd. Chauvin and colleagues were enduring the insults and threats of the hostile crowd. This back and forth panning was physical conduct on the part of Chang that strongly reinforced his stated perception of the crowd as aggressive and threatening. He kept looking over there to see if he needed to go and help. The commentary of Hill, Hall, and Charles Mcmillian was particularly helpful to the defense. I'm going to quote just a little bit of it here, but Hill can be heard exclaiming aloud, "Man, Floyd still won't get in the car. Just get in there, George." And stuff like, "What is he doing? Now he's going to go to jail." Maurice Hall can be heard muttering. Oh, by the way, Maurice Hall is also heard giving a false name, fake identification name to the officers on the scene. I believe he called himself Ricardo, obviously attempting to avoid identification by police. But he can be heard muttering about Floyd. He's over there fighting with the law and S-word. Mcmillian is heard telling Hill and Hall, I saw everything. Floyd effed up. He effed up. I tried to get him into the car, told him he can't win. It was pretty good stuff for the defense. So I've embedded the direct questioning of Peter Chang in the text version of today's content. Cross-examination of Chang was conducted by Prosecutor Frank. I would describe that cross-examination as ineffective, frankly, but again, the cross is also embedded in the text version of today's content. The third witness that I'm going to cover in detail here, somewhat detail, is Shawanda Hill. This is the female passenger in Floyd's SUV and also described as his ex-girlfriend. She appeared in the body camera footage of Officer Chang, as I just described, but she also appeared in court today to testify in person. And remarkably, overall, her testimony was favorable to the defense, which would explain why, despite her being Floyd's ex-girlfriend, she was called as a witness for the defense and not by the state. The most important part of her testimony for the defense was describing how Floyd was initially, over the course of their stop at Cup Foods, pretty regular in demeanor when he first attempted to pass a bad bill in Cup Foods, but that shortly after returning to the Mercedes SUV, he suddenly fell asleep. Indeed, he fell into such a deep sleep that she could not rouse him, or when roused, he immediately fell asleep again. It was bad enough that she gave up the idea of getting a ride home from Floyd and called her daughter to come pick her up instead. Once Nelson got that testimony out of her, he was pretty much done with her direct questioning, which again is embedded in the text version of today's content. On cross-examination, Hill surprisingly presented some difficulty for Prosecutor Frank. At one point, when he was having difficulty getting a straight answer out of her, she kindly offered to explain if he liked, and he invited her to do so. Accepting his invitation, Hill immediately began a lengthy monologue about how, Floyd had tried to pass a bad $20 bill and he wouldn't wake up when police were knocking on his car window with a flashlight, and how she was desperately trying to get him to rouse and comply with police. And at this point, a horrified Prosecutor Frank abruptly interrupted her, and she looked at him accusingly and said, "You said explain." Cross didn't go any better for Frank after that. Floyd fell asleep? Yes. But you woke him? Yes, but then he fell asleep again. But he woke up then? Yes, but he was not coherent at the time. Frank switched to asking if Floyd had expressed chest pains or shortness of breath or similar symptoms of a heart attack, which Hill said he had not. So Frank says, other than being sleepy and nodding off, he seemed normal. Well, yes, Hill agreed, he seemed normal. But as an observer, folks, I can tell you that sounds like normal for an opiate addict high on fentanyl. In any case, that was it for cross-examination of Hill, and of course we've embedded that cross in the text of today's content, as well as a very brief redirect of Hill by Nelson. So there were three other witnesses today. The witnesses were retired MPD officer Scott Creighton, involved in Floyd's year-earlier arrest-related drug ingestion event, and whose testimony, the best part of it, included body camera footage of that event. It was very much identical to Floyd's erratic behavior on the day of his death. There was also retired paramedic and nurse Michelle Mosang involved at the same event a year prior, drug ingestion, arrest-related, and she was a person who had observed Floyd's sky-high blood pressure of 200 over 160, folks. That is remarkable. And finally, Minneapolis Police Department Medical Training Coordinator Nicole Mckenzie, who was recalled as a defense witness after testifying for the state earlier in the trial. Their testimony is relatively short. Nelson got through them quick, and cross-examination did not take a long time. And partly as a result of it being short, it's worth listening to, although, frankly, it's worth listening to on its own merits as well. But I'm afraid I'm out of time for providing commentary on it, and in any case, it generally doesn't require in-depth analysis. You'll understand everything that's going on in that testimony yourself. I have, of course, included the video of all their testimony, cross-examination, and where relevant, redirect and recross for Creighton, Mozang, and Mckenzie in the text version of today's content. Okay, folks, that's about all I have for all of you this evening for our end-of-day wrap-up commentary and analysis of today's court proceedings. Don't forget to join us again in the morning for our live streaming and live blogging of tomorrow's court proceedings, as well as for tomorrow's end-of-day wrap-up and commentary and analysis as well. Before I go, in view of the ongoing riots raging presently in Minneapolis and, frankly, likely to explode across the nation when this case arrives at a verdict or even a mistrial, I've also taken the liberty of putting together a special opportunity to access our best-selling course, Lawful Defense Against Rioters, Looters, and Arsonists. That's available both online, streamed, and in DVD format. You can learn more about that limited time offer, folks, only while this trial is ongoing, which is only a few more days, by pointing your browser to lawofselfdefense.com/rioters-sale. lawofselfdefense.com/rioters-sale. And thanks, as always, to both Legal Insurrection and CCWSA for the support that makes my coverage of this case possible. All right, folks, until next time, I'm Attorney Andrew Branca for Law of Self-Defense. Stay safe.